Well, I want to thank everybody for joining us today. My name is Elizabeth Hosier, and I'm the Director of Programs at the Robert H. Jackson Center. Before we begin, I do want to briefly highlight a few of our upcoming programs. And for those of you who may be new to the center, our mission is that we envision a world where the universal principles of equality, fairness, and the rule of law and justice prevail.
I think chronologically, I go first, as I'm going to speak for about 10 minutes or so, and have a historical lens on the Nuremberg topic 80 years ago, but also the precedent that it embodies, which carries forward into the contemporary era, where David has been one of the leaders in international law development. I want to speak about three major topics. First, what Nuremberg was. Second, what makes for a just prosecution or legal accountability process, some qualities or defining characteristics. And third, how that list of things was delivered at Nuremberg 80 years ago. So, first, what was Nuremberg? Nuremberg is a city. It's a location in southeastern Germany, in Bavaria, about 100 kilometers north of Munich. And Nuremberg during the Nazi period, 1933 to 1945, was a spiritual home of Nazism, a symbolic city, the site of Nuremberg party rallies, the site in 1935 of the promulgation of the Nuremberg laws, which drove German Jews out of citizenship and into emigration, poverty, and far worse. And it was a site that, after the Nazis were defeated, was in the American sector of military occupation. And so the Nuremberg trial process happens at this location because, in a geographic sense, it's in what has become the United States. It is secured by the U.S. Army, and it's got a largely intact prison and courthouse complex, which was available to hold a large legal proceeding. The large legal proceeding was something that had been in the planning, certainly for a couple of years and maybe for a couple of decades. You see, after the First World War, the idea of accountability processes for those who started it, the aggressors, and for those who perpetrated international treaty violations, war crimes in that time period, died a borning. It really did not get off the ground, and the perpetrators, if you will, of the Great War, the Kaiser at the top of the list, went forward into civilian life, stayed in comfort, retirement, old age, and no accountability. So after it had happened again, and a generation who, as young men, and it was almost entirely men, had experienced it back then, and now as middle-aged and powerful people have experienced it a second time, the idea was to do better. And the planning during the war period was for, after the victory, the inevitable victory is achieved, the economic and military might of the USSR, the United States, and the United Kingdom meant that once that alliance was cemented, it was a matter of time, long and horrible and high toll time, but time before victory would be achieved. And then what to do with the perpetrators, those who had started it. Elizabeth referred to atrocities, and there was prosecution of atrocities at Nuremberg, but the grand atrocity, and really the focus of Nuremberg, is aggressive war, is starting it, is violating the norms, the treaties, the civilized commitments that forswear war, which largely had developed in the decade between World War I and the Nazis coming to power. And so that's the idea of an accountability process. It requires fighting and winning the war, and then it requires a fair amount of diplomatic effort to negotiate among the differing legal systems what together can be an international process. And that happens during the summer of 1945. That results in the creation of the world's first international criminal court, the International Military Tribunal, called military because it was functioning in the land of military occupation that had previously been Nazi Germany. The International Military Tribunal is a four-nation court that is set up by executive agreement across the nations. Again, the UK, the US, the USSR, and the newly liberated, reconstituted French Republic. Those four nations each appoint a judge and an alternate judge. In the end, they function as a bench of eight. And there are procedures that are agreed to do a public trial with what we would call the due process components, largely of the American Bill of Rights. There also is jurisdiction that is defined. This tribunal has jurisdiction over four crimes perpetrated by the Axis powers in the European theater: common planning or conspiracy, the waging of aggressive war, the commission of war crimes, and the commission of crimes against humanity. And then, beginning in the fall of 1945, this process, which is gathering evidence, which is apprehending fugitives, which is preparing possible charges, delivers an indictment, repairs a courthouse, relocates to Nuremberg, and in November commences the world's first international criminal trial. U.S. Supreme Court Justice Robert H. Jackson, who this center commemorates, is the American chief prosecutor, appointed by President Harry Truman. And Jackson opens this trial on November 21, 1945, and it runs through the bulk of the next three seasons: the winter, the spring, and the summer of 1946. The judgments are rendered on over 20 individual Nazis plus six Nazi organizations that were charged criminally with one or more of those four crimes. And over those many months, the world had a vantage point to see justice being done. Did it have an element of vengeance or catharsis? Of course it did. These were the Allied powers who had paid such a high price to fight and win this war. But the point, as Robert Jackson said in his opening statement, was not to give in to vengeance or to do it for vengeance, but instead, in his actual words, the great tribute that these powers play is to surrender vengeance to reason. And they subjected themselves to public scrutiny in doing that. So let me turn to my second topic. What are some of the characteristics or qualities that make for a just prosecution or legal accountability process? I'll identify seven and a list for you to reflect on. The first is government power. Without peace, without a control position, there cannot be law enforcement. Think of the Wild West, and then think of Wyatt Earp, or whatever metaphorical figure you want to think about, coming to the Wild West, bringing law to the wild. Or think of a war, and then think of peace and control and occupation. So government power is a prerequisite to prosecution, always was, always will be. Second, government consensus in this international realm that this project is a shared value and a priority that we will commit our best talents to, our national resources to, and do together. Third, pre-existing law. As a matter of legitimacy, we don't think rules made after the fact are fair things. That's embodied in the US Constitution and the prohibition on ex post facto crimes. And that's the notion that the law has to provide notice so that people can elect to be law abiding or lawbreakers. So pre-existing law, norms, criminal requirements have to pre-exist. Fourth, international and or entity predication. In other words, a factual basis to think that these particular people may have in their conduct run afoul of pre-existing law. Facts, in other words, suggesting that crimes have been committed. Fifth, living subjects, and then, as evidence develops, targets of investigation who can become defendants. Otherwise, we're just doing historical inquiry. We're talking about absentia, which is not generally a legitimate process in prosecution. Six, public charges, bringing to the light of day, to the eyes of the public, the accusations against individuals that will be the basis of prosecution. And seven, capacity and commitment to deliver due process, fairness to those defendants. This has a number of subcomponents. A court that is independent, that is honest, that is populated by capable judges, capable, independent, and legally trained defense attorneys, public proceedings, trial rules that bind the government, that hold the prosecutors to various burdens and standards, and finally, resources for defense counsel to fairly represent the accused so that it's not a rigged proceeding. Those are some of the things that I've extracted from the London Agreement that set up the IMT. You could extract them from the American Bill of Rights. You could extract them from the penal law in every American state. You can extract them from the U.S. Criminal Code. These are, I think, standard components of justice and accountability. So finally, third, and very briefly, how was that delivered 80 years ago at Nuremberg? Well, the Allies had won unconditional surrender, so they had power. They agreed that this project of prosecuting the perpetrators of aggressive war, having failed 30 years earlier, was worth their time, their resources, and their best personnel. They believed and they defended the pre-existing nature of the law in national law and in international treaty commitments that forswear aggressive war and war crimes and human rights crimes before the Nazis engaged in any of that. Fourth, there was predication. There had been years and years on the front page of every newspaper, and in the experience of so many soldiers and all of their families and defense workers, evidence of Nazi aggression. There were survivors. There were ample predication. There's no need to belabor that. Fifth, there were some living subjects that that predication pertained to. There was no more Hitler. There was no Himmler. There was no Goebbels. There was Goering. There was maybe Bormann, and he was prosecuted in absentia, but the inner circle of household name Nazi leaders, if you will, those who did it as decision makers, had some surviving representatives, and they had become Allied prisoners. Six, public charges were rendered. The Nuremberg indictment of October 1945 is a long, comprehensive document written with care and delivered in print to each incarcerated person it charged with crime so that they and the defense attorney they got would be able to work to defend themselves. And finally, seven, capacity and commitment to deliver due process. The Nuremberg International Trial of 1945-46 was each of the things that I ticked off. It was a court that didn't work for the prosecutors. It was an independent and honest court of capable judges. It was capable legal defense attorneys working zealously to represent the accused. It occurred in public and had a large balcony filled with reporters who every day sent out wire service reports and newsreel films to show the world what was happening in courtroom 600 at Nuremberg. It was a trial bound by rules. Each prosecution had a sector of the case and they had a burden of proof beyond a reasonable doubt. The tribunal had a 3 or 4 judge for any judgment of guilt or any punishment requirement built in, a supermajority requirement. It had a rule of evidence that was largely generous and allowed the defendants to bring in what they wished and to have compulsory process to bring in witnesses. And it paid for those defense attorneys. It was actually in the wreckage of Germany for the surviving defense lawyers who were capable of this job, and some of them were quite unrepentant Nazis, what we would call a very good gig in 1945, 1946, because they got American paid housing and mess privileges and office staffing and support personnel and reproduction of document resources to do the job of defense lawyering. So was Nuremberg perfect? Justice Jackson said at the time and in the years afterwards, far from it. Was it a good faith effort to do as a startup, as best they could in the compressed time and the complexity of this situation, a fair accountability process against the chief perpetrators? He believed so. He so argued to the tribunal, and in its judgment, it generally so found as a legal matter and in convicting the individuals.
Thank you, John. Really appreciate these important remarks. I can't think of a better person to discuss this topic and to bring in Justice Robert Jackson and all of the things that he had to think about when he was asked to go to Nuremberg and seek justice for horrors that were beyond imagination. I also want to thank Elizabeth and the Robert H. Jackson Center for this important series and also this important topic, because it is a fascinating topic. In other words, bottom line is, what does a prosecutor think about when he gets that phone call from Harry S. Truman, from Kofi Annan? Would you be willing to be a chief prosecutor in an atrocity zone to seek justice for victims of atrocity? And then where does that go? What happens after that? We all kind of know about the law and the types of crimes that are prosecuted, but what is that prosecutor, thinking about when he has to consider all of the aspects of a fair and open prosecution? It's interesting, the similarities between the International Military Tribunal at Nuremberg and the UN Special Court for Sierra Leone are really apparent. One of the things is that they were located in an atrocity zone. They weren't in The Hague. They weren't removed from the pain and suffering. Like Robert Jackson, when he was being driven into work every day, he was seeing destruction and ruin and hopelessness. The same thing happened to me because we relocated very smartly, and I think this is really critical, and we can talk more about this in question and answers. But a international tribunal that's located in the crime scene is a symbolic act and one that brings hope potentially to victims of atrocity. We were right in Freetown. Just like Nuremberg, it was ruin. There was no running water. There was no electricity. I recall when we first got there in August, because there was no running water, we would shower in the rain. Fortunately, it was a rainy season, and so we'd go out and shower in the rain. So again, it's not glamorous work either by any means, even though Hollywood tries to make that glamorous. It was dirty, it was gritty, it smelled, but the Special Court for Sierra Leone, like Nuremberg, we were right there seeking justice for victims. Just chronologically, I just happened to be, and I'm certainly not comparing myself to that great man, Robert Jackson, but I happen to be the first American since Robert Jackson to be a chief prosecutor at an international tribunal. So the general concept of prosecution stems with a strategy. In other words, you have to sit back and think of several things, but one of which you have to actually figure out who, what, when, where, and why, particularly looking at your mandate. My mandate was to prosecute those who bore the greatest responsibility for war crimes and crimes against humanity. That's my charter, and that's what gives me the right to go in and seek justice for those victims. So you have to think, all right, what does that mean? Well, obviously, that means human beings that have committed crimes and the crimes that they committed based on that statute. And one of the things that I think is very similar to Nuremberg is that for the first time in history, in modern histories, is that the mandate for the UN Special Court for Sierra Leone, which was the world's first international hybrid tribunal, was greatest responsibility. And it was very similar to Nuremberg. In other words, and I'm the first modern chief prosecutor to had to interpret the idea of what is greatest responsibility. And I used the example of Nuremberg. In other words, the central figures in the tragedy, the central figures in the crime, so that I had three sets of combatants, and so I chose to prosecute those who were heads of those combatant groups, the Revolutionary United Front, the Armed Forces Revolutionary Council, and the Civil Defense Force. But I used Nuremberg because the IMT at Nuremberg, the famous one, not the Council 10 subsequent trials, but the one that everybody associates with Nuremberg, I used that as the model because that's what Robert Jackson and his team of prosecutors did, is they basically prosecuted those who bore the greatest responsibility for the tragedy that stemmed from the Nazi regime. So that was very similar, and I think that's important because that's how you begin to think about other aspects of prosecution. And there are 5 considerations in developing that prosecutorial strategy. And the first one, and it's an obvious one, is the legal aspects. All right, you take your mandate, you look for your subject matter jurisdiction, which is war crimes and crimes against humanity. Look for your in personam jurisdiction, those who bore the greatest responsibility. And then you have your temporal jurisdiction, and that is since 1996. So, that sets up the legal basis and the legal perspective by which then you think about seeking justice for the murder, rape, maiming, and mutilation of over 1.2 million human beings in Sierra Leone. But there are four other critical aspects of thinking about prosecution. And as a footnote, prosecutors are legally bound to seek justice, not to win a case, but to seek justice. And I think that this is really, really critical. We're not out there just to prosecute bad guys. We're there to ethically, under the law, consider who should be prosecuted for whatever crimes they have committed. So I think that's really important. Prosecutors, whether it be at the domestic level or at the international level, are sworn to seek justice. All right. And that's very important, so that you're not just prosecuting everybody, you're prosecuting those under your mandate. But also, if you find in your investigations that someone didn't commit the crime, you're ethically bound to take care of that and to not charge that individual or withdraw charges if, in fact, you find exculpatory evidence. Well, not only is there, of the 5 considerations, legal aspects of this, but there's also the political considerations. When you arrive at a atrocity zone, whether it be at Nuremberg or whether it be in Freetown, Sierra Leone, there are political ramifications to your power. When I arrived in Freetown, I was in some ways the most powerful person in the region because I had the mandate to prosecute heads of state. But if you go in with blinders on and don't consider what happens if I do X under your prosecutorial strategy or Y, that there is a political blowback that actually harms the ability of the court to seek justice for the victims. So there's the political aspect that you have to consider when you arrive in a war-torn region of the world. Just as importantly is, and go back to political, tribunals are creatures of political compromise based on political events. So the politics is in the DNA of tribunals, whether it be at Nuremberg or whether it be in Freetown, Sierra Leone. Politics is in the DNA. And so you have to consider that all the time, the political ramifications, because again, that could come back to haunt you. Another aspect is the diplomatic part of your prosecutorial strategy. You are working in and around diplomats who have basically a stake in this. And so you have to work with the diplomats in the country, in the region, and internationally to make them understand that you're not here to disrupt, but to enhance and to help. And so I went into Freetown, Sierra Leone humble. In other words, I always told the press as well as the diplomats is, I'm only a star in a large galaxy of individuals and organizations who are trying to correct the horror of that 10-year civil war in Sierra Leone. So you have to be you have to consider the diplomatic aspects of all of this as you begin to develop a prosecutorial strategy. And then you have to just look at the practical aspects of it. Where are you going to hold it? Where is the court? How safe is the court? All the security, the logistics, the practical aspects of what you're doing, getting to work, the security of your people. Are they going to be able to get to work safely and return safely and live safely? These are the very same things that Robert Jackson considered when he was at Nuremberg too, because it was the same circumstance, a destroyed area that had a lot of people who were angry, upset, who did not like the court being there, who had revenge on their mind, and would want to, in fact, disrupt the court if that was all possible. So security and just the real practical aspects of just being there. In a country that had every known disease in the world, I was asked a question, what kind of diseases can you get in Freetown? And I said, that's the wrong question. Is what diseases won't you get in Freetown? So you also have to think about the health of your group. We had to cross-train our individuals. So at any one given time, I had somebody with malaria or yellow fever or what have you, cholera, diphtheria, that couldn't come to work because they had these diseases. And so you had to shape and mold the practical aspects of prosecution. And the last point I want to make related to the 5 considerations of developing a valid prosecutorial strategy is the cultural aspect of that. I'm in West Africa. I'm in Sierra Leone. I'm in this is not Europe. This is Africa. And so you have to think, is the justice I or we seek the justice they want. Think that through. These cultures have been around for millennia, and they have their own concept of justice, and it's correct. It's a center point. Family is a center point of their society, but the paramount chief system is the center point of local justice and accountability. And so you had to bring in the paramount chiefs. You had to go out and listen to the people. And I created the world's first outreach program that went, and I asked my things that you learn in law school, and John can certainly agree to this. If you have a client come in, you ask them what happened. And I just went out and just asked the people, what happened to you? Tell me what happened to you. And so that was also very important. So is the justice we seek the justice they want? So that's very critical. So these are the 5 things that I want you to remember today is that when you're considering seeking justice for victims of atrocity, you have to consider the legal aspects of it, of course, but also the political and diplomatic considerations related to you being in that area, doing what you have to do under your mandate, but also the real world practical parts of that, and then, of course, the cultural. So I hope I've sparked some interest. John and I are very much looking forward to hearing your points and your questions and your answers. So I'll turn it over to Elizabeth, and we'd be glad to have a good dialogue.
Like when we talk about prosecuting mass atrocity, what is the core purpose of international criminal law today? Has it changed a lot since Nuremberg?
Well, just real quickly, and I'll let John jump in. It certainly has. Really, Nuremberg is a cornerstone of a beginning. And it was in the history of international accountability, part of a flow towards and a thinking of perhaps law can be used as opposed to vigilante justice. And I don't want to go into too much of a lecture related to the history of this, but Nuremberg was the first attempt to truly bring nations together and say, we could probably do this under law versus going out and hanging them. And there's a great story about how Winston Churchill and Joseph Stalin and Franklin Roosevelt approached what we wanted to do with the Nazis after the war was completed. And I'll let John talk about that. But yes, very much so. We had a blank space but after Nuremberg, and that was because of the Cold War and the world kind of separated in two with a few other nations. But, there was very little bit of accountability, even though there was a lot of atrocity. Do you know that during the Cold War, as many people were impacted by the Cold War as they were in World War I and World War II? The Cold War was a massive human rights violation. And there were wars going on and internal conflict that saw the massive destruction of human beings. But something happened in the 1990s as the Soviet Union melted away. The world began to think about, because we had some tragedies going on in the Balkans and then quickly in Rwanda, is what do we do about that? And so Nuremberg was the example of perhaps we can fast forward those crimes and the concept of nations coming together. Of course, by this time, we had the United Nations. At Nuremberg, we didn't. We had the beginning of that, and they were working on that, but at the end, it was being created as Nuremberg was actually being prosecuted. But the point is that so we had the capacity then to bring nations together to decide what do we do about the Balkans and then quickly Rwanda. And so they created the international system, the ad hoc tribunal system. And so then the question is what crimes were committed? Because again, at the international, in the domestic level, you have statutes, you have laws that you can use to criminally prosecute people. But at the international level at the time, we had to go back to Nuremberg in order to look for the jurisprudence. You just can't make up crimes, and that's what you just don't do. So you have to actually have a jurisprudential basis by which you charge. But Nuremberg was the cornerstone, and we were then able to take that and move it forward to prosecute atrocities in Yugoslavia, Rwanda, Sierra Leone, Cambodia, and of course also towards the latter part of the 1990s, we see the Rome Statute being signed and the creation of the International Criminal Court. So it all goes back to Nuremberg. But the jurisprudence is amazing now with all of these major tribunals. We have created the jurisdictional capacity to prosecute heads of state who feed on their own citizens. That was something that Robert Jackson did not have. I had that. Subsequent prosecutors, particularly with the brand new special tribunal for the crime of aggression against Ukraine, we in all of this darkness and this dust in the air, we actually created another international tribunal, and we can talk more about that. I was very much involved in that, but again, that's an aside. So we've come a very long way jurisprudentially since Nuremberg. John, I'll throw it over to you.
Yeah, I agree with all of that. I would say that the force of the precedent of 1945, 1946 turned out to be really quite strong, even though the Cold War period parked it for about 50 years. In the sort of few years, the sweet spot of the mid 1940s, the United Nations is created, the Nuremberg Tribunal and judgment occurs, the United Nations General Assembly adopts that, the Genocide Convention is promulgated, goes out and is ratified and comes into effect. The Geneva Conventions of the late 1940s, there's a lot of legal development. And for the future after 1946, it's a fact that there has been a Nuremberg. And so that turns out to be precedent and inspiration and role model for the post-Cold War period when, thanks to modern technology, in basically real time through CNN, the world saw what was happening in the Balkans and the world saw what was happening in Rwanda. And the absence of a sort of fractured Cold War landscape meant that the United Nations could function and create ad hoc tribunals, and some of the traction resumed that had been there in the 1940s. And of course, that's continued fitfully with complexity, but over a 30-year period since then. And so the layers of development continue to build upward. And it's never done, and it's never entirely successful. But I do think it's fair to regard it as a very significant 80-year story of progress.
John brings up a good point. After Nuremberg, and I probably should have mentioned this, is from a jurisprudential point of view, we did have the United Nations created, which basic principles were we settle our disputes peacefully and we don't use force, but as a last resort. So that was very critical. Also, very importantly, the Universal Declaration of Human Rights was signed into law by a treaty. It's a short document. It's a major document because for the first time in the history of mankind, morally and ethically, religiously, I guess, human beings had a right to exist. But the Universal Declaration of Human Rights, among other things, it gives you a human being a legal right to exist. And so if you violate that, jurisprudentially, that allows a future 1990s, early 2000s prosecutor to take the concept of under international law and say depriving somebody of their lives is by chance a crime. So that, we tend to step over the Universal Declaration, but at the end of the day, that's a pure and simple concept that is very important as we create these new modern day tribunals. And of course, we had the Genocide Convention, very critical, but then we also had the true codification finally, even though we did have some in 1926 and other places. We had the codification, the Geneva Conventions of 1949, and there's been some protocols additional, but the bottom line is it protected human beings found on the battlefield, the wounded and sick at sea, on land, prisoners of war, and certainly the protection of civilians found in concept. So I thought I'd kind of digress a little bit, but that is Nuremberg, and those four things that happened afterwards are the bases by which modern international criminal law now is based and has the capacity to seek justice for victims of atrocity.
One of the questions that came in is why do these international criminal proceedings take so long? And I bet you can answer that pretty well, David.
Well,
Well,
let me quickly
yeah, please, John,
interject
go
just
ahead.
before. Nuremberg did not take so long. Nuremberg,
Sure.
Robert Jackson quipped, got to trial faster than a lot of personal injury cases get to trial in New York State. And that was, I think, the improv and chaos and maybe imperfection of Nuremberg, but they worked very quickly from a May 1945 Nazi surrender and the start of military occupation to beginning this trial in November and completing the trial at the end of September 1946. So that's a relatively expeditious uh, startup process. I think the answer, and I'll turn to David, is that by some standards, things take a long time because due process is a commitment to spend time.
No, that's right. Great point, John. And that's exactly right. We don't, it was funny. I was testifying for the Security Council when I was chief prosecutor, and the world was really angry and a little bit frustrated with the tribunals in Rwanda and Yugoslavia because they were taking too much time. It was really, and I was asked, if we give you more money, could you do it faster? And I kind of chuckled to myself and I said, they're just missing the point entirely. Money has nothing to do with it, though it's important to support these courts. But it basically boils down to a strategic plan, and a prosecutorial plan allows for a more efficient and effective prosecution of individuals who commit atrocities. And that's what I was approached by. When I was asked by Kofi Annan to go over to West Africa and to seek justice for the people of Sierra Leone, the two other tribunals that in existence at the time, Rwanda and Yugoslavia, had been in existence since 1993/94, and they were lumbering along. And again, this is not meant to denigrate the important and hard work of many people in those tribunals, but they were lumbering along. And they were expensive. They were at about $125 to $130 million per year per court. And at one point, it was sucking down 20% of the UN budget. And so when the president of Sierra Leone reached out to the Security Council and to Kofi Annan saying, I need help over here. I can't solve this. So they decided to create another international tribunal, but immediately the pushback was, we don't want them to look like the ad hoc tribunals in Rwanda and Yugoslavia because they're taking too long. And I'll just kind of give you a vignette. So I was being interviewed and I began to develop a general strategy, a strategy of how we're going to start, what we're going to look like in the middle of this, and how we're going to stop, how we're going to close the court. When do we know when we're done? And so they brought me on as much as a manager and someone who can plan and create a new organization because they asked me, can we do this more efficiently and effectively? So, the question that was asked here, why does it take so long, is a good one, because that's when I talk about, when you're talking about the 5 considerations of prosecutorial strategy, that's a political problem. And the longer it goes on, the less political support you get. And there's a real threat of potentially closing the court. You're just taking too long and we don't know what we're getting. And so I developed a strategy where I could go in front of the Security Council or nations contributing and say, here's where we are now, here's what we're using with the money and why we're using it, and here's what we're going to need next, so that I developed a general strategy. As it turns out, the Rwanda and Yugoslavia tribunals did not have a general strategy. They were using all this money and time, but they could not tell the Security Council what they were doing, why they were doing it, and when they were going to do it. And because of that, both of those important tribunals, I really want to underscore this, took a long time, in some cases 20 plus years. So the criticism was rightful. Now, the Special Court for Sierra Leone was the last to be created and the first to finish because we had a plan. And I think that now has been kind of the way we have, as we began to develop the Special Tribunal for the Crime of Aggression against Ukraine. That's how we approached creating that court, which took us 3 years, and it came into being in June of 2025. And now the practical aspects of creating, as I've told you, creating that tribunal are starting. But it's a rightful criticism. But I think John's point is correct. We don't we do think of time because there is a political ramification. And so I was thinking of time, and I came up with a way by which we could do it more efficiently and effectively. So we did it. I had planned on 6 years, but the world didn't give us Charles Taylor for 2 years after the 6 years. So, it took about 10 years for the special court for Sierra Leone from the very beginning and the middle and end to finish its work. But that's just part of the system, due process. It's the law and the due process that drives the train, not time and money, even though you do have to, as a chief prosecutor and as a senior member of the court, always be mindful that politicians and diplomats are looking over your shoulder. And if it gets too long without a strategy, they could shut you down. And then, of course, the victims of the tragedy do not get justice. So it's a fair question. It's a good question.
I would say kind of in that same, kind of line, somebody asked about the considerations in setting up a court in the country where it happened rather than at the ICC or The Hague. And I think you can probably talk to that about with the Ukraine tribunal as well, perhaps.
Well, John, I'll let you talk about Nuremberg, and then I'll segue into Sierra Leone
Well,
and
yeah, Nuremberg, I can be quick, was the site of Nazism. It was military occupation. It could be secured, and the defendants were the arch criminals, the decision makers whose crimes were not located in one particular venue. So it wasn't a matter of a concentration camp commandant being held accountable at a site in the occupied East, or a war criminal on a battlefield who shot surrendering soldiers being held accountable there, or occupation dictator being held accountable, Quisling in Norway. These were the arch perpetrators whose crimes didn't have a particular location, but this heart of Nazism was now the heart of Allied military occupation. It had the facility, as I mentioned, and so it was a logical thing to do there. There wasn't a Hague, there wasn't an alternative that was considered. I do think it's generally a good thing not to be too distant or to be too comfortable. And Nuremberg was very proximate and it was extremely uncomfortable. And that helped focus and it helped speed do the work.
again, it was politically smart to put it at Nuremberg. It was so symbolic, and it had to show the world as well as the German people that the rule of law is the cornerstone to the future and to the present. And it had to be at Nuremberg.
Yeah,
It
there
could have
definitely
been.
was a didactic objective to, you know, show the German people, if you will, what these arch criminals were being held accountable for, not to exculpate the German people, but not to prosecute the German people either, to create a distinction between the defendants in the box and the crimes they were charged with in this accountability process, and the audience, if you will, which was a population that the world hoped would be peaceful, constructive, human rights abiding. I mean, all the things that developed in West Germany and then Germany are in some sense successes of that educational process.
And as we stumbled into the modern era, it just so happened, of course, Yugoslavia and Rwanda were very much removed from the crime scene. And by happenstance, they decided when they were putting together the statute and the mandate, is they decided to put this international tribunal on the crime scene, just like Nuremberg, as I alluded to in my open remarks. The ideal would be it would be great to do that because we create tribunals, and this is something that we always have to remind ourselves, why are we doing this? And the answer is for and about the victims. And if the victims can see justice happen in front of their eyes, that is a huge symbolic and practical victory. That, if you're in an atrocity zone where the rule of law doesn't exist, if you can show the power of the rule of law, that gives them hope for the future. It's more than just law. It's just the reality that perhaps we may have a future. And that's really critical. And, as we were putting together the special tribunal for the crime of aggression on Ukraine, we can't keep it in Ukraine. It would be ideal if we could. But for the first time in history, we have an actual defendant that can destroy the court in its entirety. I mean, entirety through a tactical nuclear weapon or a cruise missile right through the front door. So we have to remove it in a way that causes Russia to pause. I mean, they still could take out the court in The Hague, but it has to be in a place where it can be safely done. Now, the key thing that has been discussed, and there will be a presence of the tribunal in Kyiv. There will be an outreach program in Ukraine so that the Ukrainian people will know that things are being done. But the point there's the practical aspect of this, and that is, uh, yeah, Putin can just make this court go away. Of course, it's a huge political gamble, but the point is this is the first time we actually have a defendant that could destroy in its entirety the court itself. So it's smart to have it in The Hague because of the right reasons. But ideally, as John alluded to, and I specifically saying, boy, if we could have a tribunal right there where the crime scene takes place. It's not a pleasant place to be, but it is an important place to be, and have the people see that happen around. Physically be created, the building of the court, the people arriving, the investigators out there, they're seeing this every day. That is important as well. But again, reality is that's more unlikely than will happen. I think generally speaking, most of these tribunals will be removed, but ideally it would be nice to have it right there on the crime scene.
We had a couple different questions come in about the ex post facto discussion around Nuremberg. Do you want to talk about that?
Well, I will recap a little bit. The idea is that war once was the prerogative of sovereign states. It was just an endeavor that would be successful or unsuccessful, resources, territory, conquering, or defeat. And then time would move on, but the law didn't care. That begins to change at the end of the 19th century conceptually, but it's not embodied really in national commitments until after World War I. And then in many bilateral treaties and in a multilateral treaty, the Kellogg-Briand Pact, these terribly injured, surviving, decimated nations that had fought in World War I, the Great War, for what reason, forswore war as an instrument of national policy. They announced we are out of the war business, that, in other words, we won't start it anymore. Now, that commitment did not set up enforcement architecture. There was no court to enforce those treaties. There was no prosecutor. So there were operational architectural developments in getting to Nuremberg that were new, that were certainly ex post facto in that sense. But I don't think that goes to the illegitimacy that the ex post facto concern is about. There's notice of what the conduct is that is prohibited or that is permitted. And so when the Nazis decide, by asserting power to get capitulation from Austria, and then when they go into Czechoslovakia, and then when they go into the Low Countries, and when they go into France, and when they go into Poland, it's against these treaty commitments that the nations, including Germany, have subscribed to in advance. So that is the answer. It's argued, it's really defined as the legitimacy of Nuremberg in setting it up, but it's argued to the tribunal. It's ratified by the tribunal in its judgment. That judgment is ratified by the UN General Assembly. And going forward, as a fallback position, if you will, even if Nuremberg has legitimacy questions, Nuremberg creates notice for the future. So no subsequent actor can wage aggressive war and say, I didn't know that was a problem, because Nuremberg put us all on notice that that is a problem, a crime.
That's really important because, Nuremberg kind of said, look, folk, there's certain things you just don't do. I know that's simplistic, but that's really kind of the way it is. And so subsequently, over time, nations and peoples of nations and armies of these nations were aware that there are certain things under law you just don't do. Now, of course, we had a hiatus, but I think that's really critical now as you begin to build the modern tribunals. You still have to make sure that in order to commit a crime, there has to be a crime for you to commit. And so we even still had that challenge in 1993, 94, all the way up through the creation of Sierra Leone, is that you have to show that it was a crime at the time that when it was committed. Now, you don't have to have like a codified law book that you pull off the library, open it up, and go, yeah, he committed that statute. The beauty of where we had in the creating of the modern international system versus at Nuremberg, we were able to use as indicators of violations of a standard, which is what law really, violations of the law are. We were able to use the UN statutory system, the protocols, the conventions, the treaties that were subsequently created over time, the human rights aspects of that, starting with the Universal Declaration of Human Rights, and moving forward, there's a whole body of law that deals with the protections of property of human beings in various settings. So the perpetrators of these horrific crimes in West Africa were on notice that you don't do these things, not just through the Geneva Conventions, but the destruction of cultural properties, et cetera, et cetera. So we had to prove it again. In other words, good defense counsel, and they should be doing this, questioning all the charges in my indictments that I sign. Why this, why that, forcing us to prove the jurisprudential cornerstone of why we're charging. And so as over time, as these courts continue, it becomes easier and easier through precedent, as we call it, to be able to substantiate the crimes in the indictment. But we were also challenged, like Robert Jackson at Nuremberg, of questioning, was that a crime at the time that it was committed? And as a prosecutor, you have to go in via either motion practice or actually going into court and showing that truly it was a crime at the time that the individual committed it.
Let me add one quick thing that's implicit in what we're talking about. Law comes first, and then it gets applied to the violators, but accountability runs all the way to the top. Head of state immunity had been a historical reality up until Nuremberg. And then head of state accountability is established. Accountability is not just for little people. And international law going forward stands for that principle. Sierra Leone prosecuted and convicted a head of state. Yugoslavia convicted a head of state. The idea of the Ukraine tribunal and the ICC charges against Putin is a potential accountability up to the level of a head of state. So law is a universal commitment. It exists first. It can be violated by anybody, and whoever you are, if you're a violator, accountability process could be applied to you.
Yeah, excellent point, John. Absolutely.
John, we had two different questions come in about Jackson's thoughts about the legacy of Nuremberg and how he handled any criticism.
He was very proud of it. He regarded it as the most important work of his life. And he had many other important things that he did in his life. He'd been U.S. Attorney General. He was a Supreme Court Justice for 4 years before Nuremberg and for 8 years after Nuremberg. But he really was a statesman. He really was a lawman, not just a judge or a neutral. And he regarded this as a creative forward step in human progress. All of what we do behind the institutions and the formalities is people, and what we do for good or for ill. And he regarded this as a huge challenge and something that he thought he had been successful in making a contribution to. He engaged in a lot of his extracurricular time from 1946 until his death in 1954 in writing and speaking and explaining and debating Nuremberg. He regarded this as generative. And so he was very proud of it. He didn't claim it was perfect. For instance, prosecuted 24 individuals, 3 of whom were acquitted. One of those acquittals, Hjalmar Schacht, particularly stung him just as a prosecutor. He thought he carried his burden of proof. But sort of stepping back from that, he realized that the acquittal by the tribunal showed the independence of the tribunal. And he used his defeat, if you will, as one of his touchstones in explaining the legitimacy of this tribunal process. So he was very proud of it. It also exposed him to harrowing, horrific, the worst of human conduct that an isolated American from the late 19th century up through the first half of the 20th century, and not himself a great war soldier, had never contemplated, experienced, imagined. And seeing Nuremberg, which meant seeing Nazism, which meant really discovering and unfolding the Holocaust over the course of that year, changed him forever. It made him much more serious. It made him much more of a humanitarian. It made him much more pessimistic, perhaps, about the worst that humans can engage in. And he thought that all mattered a lot. So he really probably shortened his life by working so hard at Nuremberg and doing double duty, continuing to work on Nuremberg in his years afterward.
And John brings up a good point. There was a personal aspect of this. Robert Jackson was a respected Associate Justice of the Supreme Court of the United States, and a potential Chief Justice of the United States. And he took that, put it on hold, and went to Nuremberg. The very same thing has happened to almost all of the current and former chief prosecutors of the modern era. I'm a perfect example. I was a very successful senior executive in the U.S. federal government. I had a great career. I had to retire from that safe, secure career and go do something that had no reason that it would succeed for various reasons. It happened to Richard Goldstone. It happened to others, Luis Marina Campo, Serge Bramitz, et cetera, et cetera. All of the 13 or so current and former chief prosecutors had to give up what they were doing, and they were very good and successful at what they were doing, and stop and change directions and walk into a darkened room that one did not know what was in that room, but take that important step to do something that they thought was important. So from Robert Jackson all the way up through to the present day, chief prosecutors take a great risk, personal and professional risk, in taking up the mantle and seeking justice for victims of atrocity.
Okay, I'm going to do one more question. I'm going to try to combine two that aren't super related, but sort of related. What happens when a nation that is not a member of the ICC, how would they be prosecuted through the ICC or another tribunal? And then also, what charges are being compiled for the current international abuses?
Well, I'll take the first part. A non-state party of the ICC, individuals of that state, if their crimes are committed on a state party, could still be within the ICC's jurisdiction, or an action of the United Nations could extend jurisdiction, or some kind of ad hoc process could be created, or the default and the preference really is a national accountability process. Any of those are possible. All of those are hard sledding. All of those require, if you will, peace, power, consensus, resources, prioritization.
Just real quickly, the three major human rights violators in the world, the United States, Russia, and China, are largely impecunious in a general sense because they are permanent members of the Security Council of the UN, which largely creates these justice mechanisms, and they have a veto power. So that removes them from the general aspect of holding them accountable. The General Assembly can, and we tried to do that through creating the special tribunal, but for political reasons, that didn't go, so we went to Europe to create the tribunal itself. So you're probably thinking of the unilateral actions of a certain individual who in Venezuela and Iran, how can he be held accountable? And the answer is most likely not, because of just the way the particular system is set up. But what we did related to, because we tend to forget this, Vladimir Putin has been has charges against him from the International Criminal Court for the abduction of children. He's in all intents and purposes an indicted war criminal. Mm-hmm. Couldn't get him for aggression for reasons I don't have time to explain, but the bottom line is we created a tribunal to make that happen. So theoretically, a international tribunal could be created to prosecute heads of state who take any unilateral action against other member states of the UN because they're not part of the ICC paradigm. But the practical aspect of this right now is little to no accountability related to that, just because it's just the way it is.
Well, thank you both so much for joining us today. I really appreciate your time and your expertise.
Our
Thank
pleasure.
you, Elizabeth, Jackson Center. David, always a pleasure.
John, always a pleasure as well, my friend.
Have a great day.
Thank you.